as a critical mass that is represented in this network. We have touched on the prevalence of sexual violence in Zambia and have attached an evidence matrix, which I believe Honorable Chair and our honorable members of the committee are going to take time to have a look at. And we have tried to be as current with our evidence or with our statistics. And we have gotten some of the statistics from the Zambia Demographic Health Survey, which was released the day before yesterday on the 19th. Of November 2025, and what we have noted from the evidence, whether it's from the police service or it's from the Zambia Demographic Health Survey or from the community, is that defilement is consistently among the most reported offenses in the Zambia Police Victim Support Unit statistics. And most of these cases involve close relatives, caregivers, neighbors, or trusted adults. The individuals who perform these atrocious acts are known in most times to the victims. The evidence matrix is showing us the category and the prevalence. It's also showing us the statistical evidence, and it's also showing us the source and also the relevance to the Criminal Procedure Code Amendment Bill. It's on page 4, Honorable Members of Parliament, and it goes up to page 6. It is important to note that 1 in 7 women has experienced sexual violence, 1 in 5 girls and 1 in 10 boys has been sexually abused before 18. 28% of girls abused are 13 or younger. And it is also important to note that the GBV cases rose from 20,540 in 2021 to 42,965 by 2023. From 2021 to mid-2025, the cases of rape and defilement reported are 4,978 for defilement and 1,002 for rape. As I stated, defilement accounts for the larger part, with 68 to 89 cases of all sexual offenses involving defilement. What we have also noted is that bail routinely results in case withdrawal, witness disappearance, intimidation, and also absconding. In practice, these dynamics mean that when alleged perpetrators are released on bail, survivors are 1. exposed to intimidation, threats, and pressure to withdraw cases, may have to continue living in the same household or community as the accused, often drop out of school or relocate due to fear and stigma, and very frequently lose faith in the justice system. Some of the impact of bail on sexual offense cases has been: 1. Accused persons abscond after being granted bail. The survivors and their families are threatened, bribed, or coerced to withdraw complaints. Witnesses disappear and cases are discontinued for absence of witnesses. There is also a perception within communities that bail kills cases. Our legal context on defilement, rape, and incest is the Penal Code Act, which is Chapter 87 of the Laws of Zambia, which criminalizes sexual intercourse or acts with a child below the age of 16, with aggravated penalties in serious circumstances. Rape is a serious felony offense which involves non-consensual sexual intercourse, and it involves women above the age of 16. Incest criminalizes sexual intercourse or acts between close relatives with prohibited degrees of relationship, also consanguinity. It is important to note that these offenses carry severe penalties, including lengthy terms of imprisonment ranging from a minimum of 15 years to life, reflecting their gravity and the profound harm caused to survivors. The criminal procedure and bail. When you look at the criminal procedure as it stands currently, there is a distinguishing that is there between bailable and non-bailable offenses. This bill that we are submitting before you on its ramifications proposes to amend Section 123 to include defilement, rape, and incest among non-bailable offenses, alongside certain offenses related to theft or damage of critical infrastructure, medicines, and similar items. I must state, Honorable Chair and Honorable Members, that for the purposes of the work that we implement and those that we protect, our focus is on rape, defilement, and incest, and that is what we are submitting on. At present, courts apply a case-by-case discretion in granting bail in sexual offences cases. In practice, this has often resulted in release of high-risk accused persons with significant consequences for survivor safety and the integrity of proceedings. The bill also introduces the aspect of forensic criminal procedures. The bill seeks to repeal and replace Section 192 of the Criminal Procedure Act to provide for admissibility of forensic affidavits and certificates, clearer rules on chain of custody. This is very important because oftentimes in the chain of custody there has been a break and we have encountered missing evidence. Reliance on expert evidence without always requiring oral testimony unless specifically requested, and better integration with the National Forensic Act. As the Network on Ending Child Marriage in Zambia, Honorable Members and Chairperson, we support these reforms or these proposed reforms because forensic evidence can reduce over-reliance on survivor testimony, particularly for children and women. As things stand, the National Prosecution Authority has been prosecuting what are called victimless crimes. Murder is one such crime where the victim is someone who is dead and they are prosecuting based on evidence. This is being applied by the National Prosecution Authority with sexual offences as well, and we hope that when this bill is enacted into law, this is going to give them the authority that they so wish to have when it comes to prosecuting victimless crimes, especially when applied to rape, incest, and defilement, where sometimes victims go missing. We also support these reforms because well-handled forensic evidence can strengthen conviction rates and reduce wrongful acquittals. Improved forensic procedures are essential in non-bailable sexual offences where the rights of both survivors and accused persons must be grounded in reliable evidence. We have heard the furrow around the proposed amendments to the Criminal Procedure Code, Honourable Members of Parliament and Honourable Chairperson. We are cognizant of the constitutional and human rights framework. Our Constitution protects, among other rights, the presumption of innocence, the right to a fair trial within a reasonable time, the right to liberty, subject to lawful limitation, and the right to dignity and protection from inhuman or degrading treatment, and the right to legal representation. We are alive to these facts as we support the recommendation that incest, defilement, and rape be made non-bailable. The Constitution also places a strong duty on the state to protect children and women from abuse, violence, and exploitation. As a country, we subscribe to many international instruments as we have provided in our submissions. And these different instruments, such as the Maputo Protocol, all require states to adopt special measures to protect women and survivors of sexual violence, ensure effective investigation, prosecution, and punishment of such offences, and provide access to justice, remedies, and support. A successful access to justice system is the one that does not only respond to or protect the victim or survivor, but also takes into consideration the rights of the accused. As a network, we believe that in light of these documented patterns of flight, interference, and intimidation in defilement, rape, and incest cases, the decision to make these offences non-bailable is reasonable, necessary, and compatible with Zambia's constitutional and international obligations, provided it is accompanied by strong safeguards, speedy trials, and procedural fairness. We have a few case studies on bail failures in sexual offences and what evidence shows. I will only cite one example. And this is one where 3 police officers raped a girl and bail was used to buy silence. They were granted bond and paid the girl's parents, and the survivor disappeared. The case was never prosecuted. I can also cite one where a father who is a foreign national defiled a child and then they were granted bail, and during a court-mandated visit defiled his daughter. When he was arrested and granted on the same day he boarded a flight back to the United Kingdom, the case had to be discontinued as he was no longer within the jurisdiction. The child survivor now lives with long-term trauma while the perpetrator remains at liberty. We also have an Indian national. We have incest where a father threatened survivors after bail. And just today as a network, we were informed by the director in the in the gender-based crimes unit at the NPA that there are times when bail is granted and whole villages have disappeared because people move in the night after they have been given money or they have been threatened. These are just some of the realities that are behind our support of making rape, defilement, and incest non-bailable. What have we learned from some of these cases that I have cited, Honorable Chairperson and members of the committee? It shows us that the grant of bail enabled accused persons to flee the jurisdiction, intimidate and threaten survivors and their families, bribe or coerce witnesses into withdrawing, and ultimately frustrate the judicial process. Several matters were discontinued because key witnesses became untraceable or the accused absconded, leaving survivors to endure lifelong harm without the benefit of justice. These are not isolated incidents, but consistent patterns documented by the NPA and our own members as a network nationwide. Together, they provide compelling evidence that retaining bail for defilement, rape, and incest undermines justice, endangers survivors, and erodes public confidence in the criminal justice system. We tried in supporting our to analyze, to conduct a comparative study on analysis with other jurisdictions. We had a look at what was obtaining in Zanzibar, which is a semi-autonomous region in Tanzania, and we also tried to go and see what the relevance is to our own context. So we cited Zanzibar, we cited Ghana, we cited India as well, and we also cited Pakistan. And we also should have cited Kenya, because more often than not, we cite Kenya for best practices and they also cite us. They have bail. There is no offense in Kenya which is non-bailable, but they have very stringent rules that surround in the granting of bail, especially in sexual violence cases. And what makes them different for us is they have a law related to sexual violence, which is the Sexual Violence Act, which we lack as a country. Our key lessons that have been drawn from these comparative analysis that we have done, we have noted that across these different jurisdictions, sexual offenses are commonly placed in non-bailable or extremely strict bail categories, especially where victims are children or women and circumstances are aggravating. Malawi is such an instance, and I seek your indulgence, Honorable Chair, that we amend our submissions and send them so that we incorporate some of these examples. In Malawi, such aggravated matters have a sentence that goes as far as death. But when it comes to looking at whether bail can be granted, there are these stringent measures that are attached. It is also important to note that bail restrictions alone are not enough, and they must be matched by speedy trials, specialized courts, and strong investigative capacity. We are alive to the fact from news and also from our own experiences that some matters take many years to conclude. And in as much as we're in support that rape, defilement, and incest be made non-bailable, we are also recommending that we have speedy trials and systems in place that provide for such. So why do we support a non-bailable status for defilement, rape, and incest, Honorable Chair and Honorable Members? Defilement, rape, and incest are uniquely high-risk crimes. These offenses occur overwhelmingly within relationships of trust. These are families and communities, and have high recurrence rates when perpetrators are released, and also high intimidation and interference risk because survivors are minors or economically dependent. Bail has also seemed to be an enabler because of the direct and indirect interference. Across our members' implementation areas, the return of accused persons on bail leads to survivors being threatened or forced to withdraw cases, family pressure compelling reconciliation or compensation, and perpetrators fleeing after interfering with key witnesses. This has severely weakened the enforcement of the law. Bail also compromises child protection systems, Honorable Chairperson and members of the committee. When perpetrators return home on bail, child survivors must share the same household or community with the abuser, face ongoing fear, anxiety, and traumatization, or drop out of school due to shame or threats. This is fundamentally incompatible with the principles of child protection. I proceed now to some recommendations that we are making. Beyond specific textual amendments to the Criminal Procedure Code, the Network on Ending Child Marriage in Zambia makes the following broader recommendations to ensure the success and fairness of these reforms. 1. Expand and strengthen court infrastructure. The actions that we recommend and propose are: construct additional magistrate and high court facilities, including specialized sexual offences and victim-friendly courts in all provinces. Use the Constituency Development Fund to support construction, renovation, and equipment of court infrastructure, including survivor-safe waiting areas and protected spaces. We say survivor-safe to incorporate all survivors and victims, because we know that there are some courts within the country that have child-friendly court spaces. Another recommendation that we can make, I seek your indulgence, Honorable Chairperson, just to cherry pick on some of them due to time constraints. We have also recommended the strengthening of the investigation and forensic capacity, looking at the fact that the bill is proposing amendments around forensic evidence. We propose the following key actions: recruit more GBV trained investigators, victim-friendly interviewers, and officers skilled in digital and forensic work. Provide dedicated transport, fuel, and logistics for GBV units. Establish or strengthen provincial forensic labs and mobile forensic units with continuous evidence collection and chain on custody procedures. We have made the recommendation around mobile forensic units because we know how expensive it is to set up and run forensic facilities. We have also recommended that we develop specialized criminal procedure rules for fast-track sexual offences courts. Introduce timelines on filing, disclosure, and trial timelines, structured schedules, handling child witnesses, and coordination across police, NPA, forensics, social welfare. This is happening. There's a multidisciplinary team, but we believe that it would be strengthened further when there's a law that speaks to this. We also recommend that safeguards for accused persons' rights be provided. We recommend that we make legal aid mandatory for accused persons without counsel, preserve the right to challenge forensic evidence and request expert oral testimony, ensure humane detention conditions and separation of remanded from convicted persons, require courts to regularly review detention in line with statutory timelines. One important recommendation we have made, Honorable Chairperson and members of the committee, is introduction of special measures. We will provide this in the amended submissions. Special measures that strengthen survivor protection and witness support. We propose that safe houses be expanded and protection measures for at-risk survivors be put in place. As a country, we have less than 20 or is it 25 safe homes within the country. We also propose that the witness protection system in our country be strengthened, provision of psychosocial counseling, court preparation, and follow-up support. We propose that this be expanded because we do not have enough capacity in this. We also propose that we prevent survivor-accused contacts through separate waiting areas and improved scheduling. As I stated, we currently have child-friendly courts and processes, and it's very easy to keep the victim and the perpetrator apart, or the alleged perpetrator. But this does not apply to adult victims or survivors of sexual violence, and hence our recommendation. Our proposal is also to strengthen Section 123 around non-bailable offences, so that we can explicitly list defilement, rape, and incest as non-bailable offences with cross-references to the Penal Code provisions, clarify that courts retain jurisdiction to ensure speedy trials and review detention, require prioritization of these cases on court cause lists. We tried to be ambitious, and we know that when you're working with a system, some of these things may not be realistic. And our mission is linked to how we tried to provide timelines, because we know that sometimes the timelines cannot be dictated as such due to different circumstances. We have also proposed that we empower fast-track sexual offences courts, clearly designate the fast-track GBV sexual offences courts for rape, defilement, and incest, apply specialized criminal procedure rules on timelines, case management, and coordination. And this we can draw on a successful model such as the economic and financial crimes rules when drafting practice directions. As things stand, matters before the economic and financial crimes court may not take beyond 5 months. And this is what we want to see even with sexual crimes or offences. We would like to recognize that as a country we have made bold strides in combating gender-based violence and in regulating cyber crimes. It is, however, important to note that for survivors of technology-facilitated abuse, their procedural pathways remain fragmented and unclear. For example, a girl or woman whose intimate photos are circulated in a WhatsApp group and other social media, or a woman relentlessly harassed online by a former partner must navigate multiple laws and several offices simply to be heard and protected. There are a lot of applications that have to be made. This gap leaves survivors exposed and undermines the spirit of our GBV and cybercrime reforms. While we have enacted the Anti-Gender-Based Violence Act and most recently the Cyber Crimes Act and Cyber Securities Act, the procedures for reporting, investigating, and prosecuting technology-facilitated GBV are scattered across legislation with no single coherent survivor-centered pathways. Existing provisions on warrants, electronic evidence, and cyber investigations are important, but they do not adequately address the unique harms, privacy risks, and rapid escalation patterns associated with online abuse. Increasingly, sexual offenders use digital platforms to monitor, threaten, or coerce survivors while on bail, making tailored digital bail conditions are essential. We therefore recommend that the Criminal Procedure Code Amendment Bill of 2025 explicitly recognizes technology-facilitated GBV as falling under GBV, set out clear reporting and investigative pathways involving the victims, support unit, and specialized cyber units, codified survivor-centered rules for handling intimate digital evidence, and provide for tailored bail conditions and interagency coordination in technology-facilitated GBV cases. Finally, Honorable Chairperson and Honorable members of the committee, we are looking at matters incidental to the effective implementation of the Criminal Procedure Bill should it be enacted. In addition to the proposed amendments, the Network on Ending Child Marriage in Zambia respectively brings the following matters incidental to the committee's attention. These are critical, operational, legal, and systemic considerations that will determine the success or failure of the non-bailable regime for defilement, rape, and incest. Multi-stakeholder coordination is important across the different departments, and I seek your indulgence once more, Honorable Chairperson, just to cherry pick some of them. Multi-stakeholder coordination. We propose the following critical actions. Strengthen coordination between Zambia Police Service, Forensics, Health Facilities, Social Welfare, NPA, Judiciary, and Zambia Corrections Service. Establish standardized protocols, clear up referral pathways, and define roles and timely information sharing. Reduce duplication and interagency delays to prevent case collapse. We also have observed one thing around data collection, monitoring, and reporting. We therefore propose that we develop a system that tracks pre-trial detention, trial duration, withdrawal rates, witness disappearance, forensic turnaround, conviction or acquittal trends, and survivor safety outcomes. We also propose the use of data for evidence-based policy review and performance monitoring. We also make the following recommendations around child-friendly justice measures. And on this one, I must applaud you as our honorable members of parliament for the support that you rendered during our advocacy process, and finally the enactment of the Children's Code Act. We have a law that responds not only the general needs of children but also their child justice needs. But we have the following recommendation. Enhance the implementation of child-friendly courtrooms, trauma-informed interviewing, presence of psychologists, counselors, private waiting areas, limits on direct cross-examinations, and privacy protections. In the previous recommendations, as you will read, we had made a proposal around enhancing staff levels. As things stand, the social welfare, the Ministry of Community Development and Social Services, which is mandated to respond to the needs of children, is grossly understaffed. And that is why sometimes when you go to court, you find that there is no staff, and from the Ministry of Community Development and Social Services, and adjournments have to be made. We also make the following proposal around forensic evidence storage and preservation. Ensure secure evidence storage, proper chain of custody procedures, decentralized labs, and timely analysis to support strong prosecutions. Technology facilitated gender-based violence is something that we are calling an emerging trend. We make the following proposals. Digital evidence and cyber-enabled sexual crimes. We propose the alignment with the Cyber Security Act and the Cyber Crimes Act, strengthen capacity to collect, store, and present digital evidence in cases involving online grooming and child sexual abuse material. We face challenges when it comes to explaining grooming and helping people understand what this is. So we would be the most happy if we saw this being aligned and incorporated. We also made a recommendation around further law reform. This is one thing that we consider ambitious because we know this is not planned yet. We have proposed the amendment of the Zambia Police Act to establish a perpetrator liaison unit which will coordinate the sexual offenders register. We have, as part of protection, proposed the creation of a sexual offenders register that is going to be managed by the Zambia Police Service. And we are hopeful that the amendments to the Criminal Procedure Code are going to trigger law reform, such as amendment of the Zambia Police Act, that we hope will have a perpetrator liaison office. Honorable Chairperson and honorable members, the Network on Ending Child Marriage in Zambia greatly appreciates the opportunity to make this submission. The evidence presented demonstrates that in cases of defilement, rape, and incest, the current bail regime has too often exposed survivors, particularly children and women, to further harm while compromising the integrity of investigations and prosecutions. We fully and wholly recognize Zambia's constitutional obligations to uphold the presumption of innocence, the right to liberty, and the right to a fair trial. Our position is that the restriction of bail for these specific offenses, where risks of interference, intimidation, and absconding are well documented, is a necessary and proportionate measure to protect victims and to strengthen public confidence in the justice system. At the same time, we respectfully emphasize that this reform must be accompanied by strong safeguards, such as timely investigations, expedited trials, enhanced forensic capacity, adequate legal representation, and coordinated survivor support mechanisms. These measures will ensure that justice is delivered both fairly and effectively in a manner consistent with Zambia's constitutional framework and international commitments. Honorable members, Honorable Chairperson, by adopting a balanced approach that protects the vulnerable while safeguarding due process, Parliament has an opportunity to significantly improve the safety, dignity, and well-being of children and survivors of sexual violence across the country. We respectively submit.
Thank you for that elaborate presentation, honorable members. Okay, so we start with the Honorable Amata, then the Honorable Fove, in that order.
Thank you so much, Chair, and I want to thank the witness for a detailed and a well-researched presentation. But then you still have to clear some of the issues, especially those issues that other players or witnesses have a bit of some reservations. Chair, there is an argument that bail denial does not deter who may be the next offender. Instead, it evaluates the Constitution, especially Article 18, Sub-Article 2A of the Constitution, that guarantees the presumption of innocence until proven guilt. So, probably, witness, you can comment on that. Then, secondly, Chair, I want the witness to comment on the issue of rape. There is also argument that among the cases, that is incest, defilement, and you also have rape. The argument is that the rape cases are a bit tricky to also classify among the cases that are non-bailable. The reason being that it is easier for one to frame the other. And you have a situation now where this person will be incarcerated for even a year without being heard. It's possible, according to the information we got, that there are those who have gone for a year or so before their case is concluded, meaning this person who is just a suspect will actually be in remand, and at the end of the day only to be found that this person was framed. I want to give an example that may be possible to happen when it comes to rape. Here is a person maybe running an office. You are in the office, then a woman just walk in tearing clothes, and of course that is after having kind of knowledge with somebody else. Then there and then screaming, and people come. There you have to be arrested. You become a suspect, of course, and you are going to be denied bail until scientific evidence is proven that you are actually not the one who actually raped that woman. Your comment?
Maybe you had talked of amending the submission.
Much obliged, Honorable Chair. Just if you look at the copies that you would have, they have not mentioned special measures and a few other things. It doesn't change much. This is something that needs to be contained because it's something that has been spoken about a lot that is sexual measures for adult victims of sexual violence, because as it stands, the Children's Code Act has provided for special measures when it comes to child victims, with holding of matters in camera, separation from the alleged perpetrator. And one of our proposals is that we include special measures around the protection of adult victims, the way they don't need to interact with their potential.
So you can proceed in answering the questions.
Much obliged, Honorable Chairperson. Thank you very much, Honorable Hamata, for that. We do recognize the constitutional and human rights framework, our Zambian constitution, which protects, among other rights, the presumption of innocence, which you have spoken about, but it also goes further and promotes the right to a fair trial within a reasonable time, the right to liberty subject to lawful limitation, and the right to dignity and protection of inhuman or degrading treatment, and the right to legal representation. We are aware of the provisions of the Constitution, and we do not want to deviate from them. What we are trying to do is create a balance by making proposals around safeguards, such as timely investigations, expedited trials, and enhanced forensic capacity, and also adequate legal representation and coordinated survivor support mechanisms. These are directly in response to the provisions of the Constitution. We are aware of the lengthy trials that exist in our country, and what we are proposing and recommending is that we have timely trials, the investigative process is shortened, and when you look at, I think it's there's a page where I mentioned that we tried to be ambitious and provided some timelines around how sexual violence cases can be managed. Integrate time-bound safeguards for speedy trials. So require charges to be filed within 14 to 30 days, mandate first mentioning or hearing within 14 days, require trials to conclude within 90 to 120 days except in justified recorded circumstances, provide automatic higher court review when timelines are exceeded. What we are trying to do is not infringe on rights. We are trying to ensure that the rights of the offender are protected by law. We are trying to ensure that a balance is struck. We have provided evidence as to why we are of this thinking, and that is because of the cases we have encountered where there is a lot of tampering with witnesses or survivors, where threats are issued, and some of those threats are very serious. In some instances, they are threats of death or of murder. So what we're trying to do is we wholly understand what the other witnesses and why have stated and why they are uncomfortable, which is why we're trying to strike a balance. We understand and accept that even an alleged perpetrator has rights by the Constitution. We also understand that there's a presumption of innocence placed by the Constitution, but we're trying to strike a balance based on the evidence that we have presented. And you spoke about rape, incest, and false accusations. If you search for research around this area, the majority of allegations around sexual offenses are true, but there is an exception where there are false accusations, which is negligible. Sexual offenses or sexual violence cases are responded to or tried based on the merits or demerits, and there is also a process or a procedure that is aligned to how you respond to them. When an allegation is made, the presumption of innocence kicks in, and when a matter is reported to the Zambia Police Service, the docket is sent to the National Prosecution Authority. After investigations are done, taken to the National Prosecution Authority, then it goes to court, and it is presented before the court for the court to make a decision. Sexual offenses are some of the most difficult to prosecute, for the very reason that they involve the alleged perpetrator and the victim. In most instances, it's two people that are present, and only two people that can give a version of the events as they occurred, unless it's a situation like the case I mentioned where there were 3 alleged perpetrators and 1 victim. So since it's a case of, for example, he says, she said, based on the example that you have given, this is where scientific evidence comes in, which is why we are in support of the amendments that touch on the adducement of forensic evidence and strengthening how we handle forensics when it comes to sexual violence cases. I will be the first to say there are negligible instances where a sexual violence case is false, but most of them are actually true and verifiable. Another thing I would like to mention is that there has been the promotion, I don't know if I mentioned it earlier, of of prosecuting victimless crimes. When a murder occurs, the victim is never in court to give their version of events of what transpired for them to die, for example, unless in exceptional circumstances where someone said something before they died or is alleged to have said something. So what happens is the case is prosecuted based on the evidence that has been adduced and the witnesses and what they are going to say. So the proposal recommendation, and this I mentioned earlier that the NPA has been doing this, is around victimless crimes, prosecuting sexual violence cases as victimless, treating the crimes as victimless crimes, where even where the victim has gone missing or their family has gone missing and there are no witnesses that can be presented in court, science or evidence is able to convince the court and the court is able to prosecute, and that has been happening, which is why a strengthened forensic mechanism in response to sexual violence cases and others is very important, because you can convict based on that, which is why I think we should have put this in here, proposing a DNA data bank. Because once you have a strong forensic system, if there is DNA evidence on site, you will be able to point out who the perpetrator was, because there's a DNA bank that has DNA for the majority of the population, and you enter it into that system and it's going to show you who the perpetrator was. So I will tell you that science in matters of sexual violence is actually a friend, and a lot can happen, a lot can be done for us to grow this area when it comes to forensic evidence, have more staff trained, have the mobile forensic clinics or facilities, and we'll be able to collect evidence. We'll be able to ensure that the chain of custody is not broken. Because remember, when an allegation is made, you go to the hospital, you go to the police, there's evidence that is collected. So we need that evidence stored in a manner in which it is not compromised and does not break the chain of events, so that when it is presented to court, the court is able to determine a case based on the merits of the scientific evidence that has been adduced. And Honorable Hamwata, if I can be allowed to state this, having worked in the sector for a very long time and having handled survivors or victims of sexual violence, I will tell you that there are times when a survivor will want to withdraw a case, not because they lied or made a false allegation, but because they are one, traumatized, two, they are being bullied within the context of their community or their homes, and three, they are not in the right mental health capacity to be able to go through the entire process. Because remember, those are allegations that have been made and have to be proven, and sometimes when the survivor or the victim is in court, it is a very traumatizing experience, and most would not want to go through that, and they would rather just say they lied or withdraw the case because they can't do it anymore.
Yes, Honorable Foga.
So as they go through these scenes, I think they are making me almost emotional. You know, when we imagine rape and incest, we are just imagining these things can happen in homes. I've handled rape in a place of work involving medical personnel, and at the end of the day, for protecting a victim, I was accused as a boyfriend for the victim. It had to take the DPP to get involved herself, that time she was a she, to to get involved and go deeper to the same case, you find that a victim became more of a victim because people at that place of work teamed up to donate money even for the perpetrator so that he may not be jailed. That is a hard-working person at work and the like. You find that it's in a medical arrangement I'm talking about. You find that I woke up with the doctor to go and do the tests. He is reluctant. The doctor is even the first one to say, no, that officer can't do that. You can't rape a person. But after he did that, he found that very night, he found evidence. What am I talking about is that you have given recommendations towards towards NPA, around NPA and the like. You have left the judiciary. You have talked about infrastructure in the judiciary. You have not talked about the corruption in the judiciary. Sex offenses attract a lot of money and people are ready to put in money to. If I tell you how that case ended, I'm even able to talk about it because it was public knowledge anyway. It was in the newspaper. The culprit was gotten in the night, taken to a different jurisdiction where the case was not, acquitted without the victim even knowing. We just read about it in the newspaper that he has been acquitted. How he was acquitted, nobody knows. The evidence was so pronounced. So, what I wanted to address is the issue of corruption in the judiciary. It exists. People eat a lot when they know it is a sexual offense. There is a lot of money that exchanges because it's high stake in terms of sentencing that you should not run away from. Yes, we'll do the non-bearable and all those factors, but even when it's established that this particular individual was found wanting, they'll get away with it because people in the judiciary have eaten money. And I'm talking about something that I've experienced. I know you didn't talk about the corruption of the judiciary. Another thing is I wanted to, I know that part of what I wanted to ask, especially Article 18.2, Clause 2, has been tackled by Honorable Amata, which I think that he heavily attended to. But I'm still struggling while you are trying to strike a balance, especially that one of your recommendations was to do with safeguard for the accused and persons. But what you mentioned there is the legal head mandatory and preserve the rights to challenge forensic evidence and the like, which to some extent, if you look at how the proposed bill has been tailored, especially section 192, it is bringing in chemistry, physics and many other factors. But we all know that infrastructure-wise, you have not talked about laboratories inside, because yes, we will have an expert in form of a chemist, a physicist, and biologist, but those depend on what is in place. You find you take some samples to government laboratories, they will tell you, no, only in cancer can do this, and in cancer doesn't go cheap. So again, another thing that comes up is who pays the price. Of course, government most of the time has been coming in because this case is about the perpetrator versus the state, and the victim becomes the witness. But the factor of infrastructure, when it comes to technology, the technology referred to, especially laboratories that are supposed to help out on sexual offenses, I think we seem to be lacking on that one. If we can have something specifically carried in that particular area.
Thank you very much, Honorable Fube. And I think the team was nodding and smiling when you mentioned the corruption. We had just phrased it generally as payments or paying off being made, but as we amend our submissions, I think we will clarify and will be very specific, because one of our members, I think Lifeline Childline, is dealing with, and it's just corruption at the courts. It starts at the police station. So today they have received information, and the coordinator for the manager for the Lifeline Childline Call Center has received a report that a police officer has received 40,000 kwacha today before we came here, as we were preparing to come here. So this is something that's systemic, and this is something that needs to be responded to with the firmness that it requires. And then when we go to page 15, Honorable Fuwe, we had recommendations, and I think I don't know if you heard me. I had made a request. I had sought indulgence from the Honorable Chairperson to cherry pick, because if you look at it, there's a lot of information in this document, and so I had requested that I cherry pick as I am mentioning some of these recommendations and issues. So I will take us to page 15. There is a component around resource allocation and funding. We may just need to expand on that. So we spoke about increasing funding for judiciary, the courts, judges, that we have increased staff also. The NPA for specialized prosecutors, because the gender-based crimes unit at the NPA is, I think, has no more than 10 specialized prosecutors in there. And we also spoke to police investigation capacity and forensic labs. But now that you have mentioned, I believe in our amendments, we'll expand on why exactly did we make these proposals. So we just put it in brackets to say labs mobile units. So we need to explain what exactly about the labs and what exactly in terms of capacity. And maybe we'll also need to expand on how exactly are we proposing this be resourced. Should it be incorporated into the national budget with its own budget line, for example? And we had also mentioned considering strategic budget allocations and targeted use of CDF for justice infrastructure. We are all asking for a chunk of CDF, but when it comes to, I think, infrastructure development, and maybe looking at the CDF guidelines, maybe this is something that can be considered by the CDF committees as we head back to our constituencies, to just have more space, because there are constituencies that are in rural areas, and when you look at your subordinate court, Honorable Fuwe, where you know where you are from, when you look at the subordinate court building in your constituency, do you believe it's adequate to respond to sexual violence cases? Yes, that's the first thing that you did. You renovated it. But if you look at some of the recommendations and requests that we have made, separation of victims and perpetrators, etc., those recommendations require actual space. And so thank you very much for your feedback. We are going to expand on these, and we will amend our submissions and send them to the Secretariat, and he can circulate them to the honorable members of Parliament. Thank you.
So we shall have one last summarized question from an honorable member. You also want to summarized?
Thank you so much, Chair, and witness, thank you so much for this presentation. I want to look at REP, which I think is not something contentious as to say it comes out, properly. Issues of rape are issues that really need to consider, seriously, because here there are some issues that because someone hates you, like we heard from our colleague here, then you'll be alleged to have committed that. Now, if you look at the bail system in Zambia, it runs from the time you are arrested, goes down into court, and you look at the time, and like we say, the wheels of justice, they turn so slow and very slow. But some people say with this they turn faster than the rocket. Now, you made mention that yes, indeed, issues of rape are prevalent,
but those that will come with the malicious, in a malicious manner, they are negligible. Meaning we accept that yes, those they exist. Now, considering the tedious way of getting evidence in rape cases, where you need evidence, you go to the hospital and the like, and looking at the time that you are incarcerated without bond, you sit there for maybe 3-4 months. Meanwhile, whatever you are sitting there, it's not that true. Coupled with the Article 18 of the laws of Zambia, which presumes someone innocent until proven. So, is it not possible that the issue of rape be left into the hands of the judiciary? Let them determine whether one needs to be, I think, in a summarized way. That is my question. Thank you.
Yes, Honorable. Maybe we combine two. Yes, can proceed.
All right, thank you so much. One which is open. Yeah, thank you so much, witness. Excellent submission, very detailed. The observance of the increase in the reporting figures for all these three areas of rape, defilement and incest, is it due to increased awareness or increased number of actual cases? Do we have any evidence in that direction? And Chair, just an addition arising from the differential sentencing between incest from a man and incest from a lady. What is your recommendation to equalize the sentencing? Thank you.
You can respond.
And last, sorry, to confine defilement to all cases and not treat for those under 16 as incest.
Thank you very much, Honorable Chinkuli and Honorable Masanje. I'll begin by responding to Honorable Chinkuli. Yes, there is a presumption of innocence, and I will repeat this. Yes, there are instances, in exceptional cases, where false accusations or allegations have been made, and I have tried to give examples of instances where sometimes the victim will just say, okay, I lied, or please just do that, so that the matter is withdrawn and they can move on with their lives because of the harassment and the threats that they have received, not only from the alleged perpetrator but also the family and those that are close, as had been mentioned, I think, by Honorable Fube. When you look at the bail system, as you have mentioned it, there are times where that this, remember, the case handles this case by case and sometimes at discretion. And when you look at the different types of bail, there are times that you will find that by the time you're exhausting the whole bail process and your matter goes to court and is concluded and you are convicted, you will begin your sentence from that date of conviction, for example. So there are times that in as much as bail it may be a right, it may contribute sometimes to lengthening of the process, because the alleged perpetrator is going to want to exhaust that, and to a certain extent bail becomes a matter of right in as much as it's at the discretion of the court, because you see the right to apply for bail, for example. So there are circumstances when this whole application for the different types of bail may end up lengthening the trial. We have in our submissions acknowledged the fact that we do have lengthy trials, and from experience you'll find that it's taken 5 years, 3 years for a conviction to be secured or an acquittal to be made, which is why the striking of the balance that we mentioned, where we are making recommendations around making the whole process timely, where the investigations are timely within a specific period, the trials are expedited, enhanced forensic capacity, adequate legal representation, and coordinated survivor support mechanisms. Unless things have changed, when you look at the cause list, for example, if it's at the subordinate court, it's a general cause list, and magistrates are given cases as it. So those that work in the fast track course, they know this is a GBV case, maybe I have to expedite it. But remember, there are competing interests. There are other matters that the magistrate may be handling. Hence the recommendation around specialized magistrates in specialized courts, so that they are not dealing with other cause list issues, hence delaying processes because they are overwhelmed and they have a lot of matters that they have to respond to. So our recommendation is based on that, and we're hopeful that when we talk about staff, there will be increased recruitment, there will be increased training to ensure we have specialized team members responding to sexual violence cases, regardless of whether it's within the judiciary, the Zambia Police Service, etc. As long as people it's in that ecosystem, they are responding to sexual violence or GBV generally. We are hopeful that we're going to see, we're going to get to a situation where there are enough resources to train and have this specialization. And then you look at the tedious way of obtaining evidence. What no one wants to see is a situation where at the end of the day someone gets off not because they were innocent, but because there were shortcuts that were taken, because there was an assumption that obtaining evidence is tedious. It is tedious, yes, and in most cases it actually re-traumatizes the victim. Hence our being in support of the innovation of handling sexual violence cases as crimes, as victimless crimes, so that the evidence is able to speak on it, so that the word of mouth is able to speak to it and the survivor is not re-traumatized. The presumption of innocence, we are really trying to strike the balance that we keep on talking about. And it's not only the sexual violence offenses, it's not only rape, defilement, and incest that are going to be non-bailable. A second offense for stock theft is non-bailable. You have, is it cannabis? And all those others where second offense is, unless the law has changed, 10 years minimum. So you have all those, motor vehicle theft, etc. We've had those, some of those at second offense, which are going to give you that. And looking at it, take time to read some of those case stories. We'll amend them, we can even go up to 50 of these stories that we have gotten from the NPA, that we have gotten from our members and from survivors directly, so that you see just what happens to victims within community and from perpetrators. There are perpetrators that have allegedly gone and defiled. The Englishman we were talking about, on a supervised visit, he defiled the daughter that he was accused of defiling the first time, and he ran away and went out of the country. So those are things that needs to be considered. So even if after this whole process the decision will be we can't make rape, incest, and defilement non-bailable, we would like to see very, very stringent conditionalities attached. Because I will give a very practical example. I used to work for the YWCA. I had a client who was 7 years old, had been molested, and she ended up with a colostomy bag, HIV, syphilis, gonorrhea, and all those things. That's a child whose life is never going to be the same. So those are things that we need to look at. That is why some jurisdictions have aggravated sexual offenses, because they are aggravating circumstances that make them as such. There is a lot of damage. There are girls that have ended up with fistula, and their way of living has drastically changed. So when we sit before our honorable members of parliament and support some of the bills and some of the decisions that come with the bills that come with them, we are speaking from experience, and we are representing the lived realities of those girls, women, children who do not have the opportunity to appear before lawmakers and implore them to make laws that are going to support some proposals or that may not be supported by some members of the general public. Honorable Munsanje, coming to you. You did ask about the increased number. Is it because of increased awareness? Is it because of reporting? I have always said it's both. Both, because we are on the ground, people are marching, and we've always raised awareness. This is what sexual violence looks like. These are the types. This is why it is important for you to report, and we have been raising awareness on the law. But I also need to speak that as we are raising awareness, we are also helping the general public out there understand what safety measures may be in place or are in place to protect those who report. Because remember, there are a lot of cases that go unreported. If I see what has happened to the other person who reported, I am not going to be compelled to report unless I'm guaranteed of safety. So it's an aspect of, am I safe? Can I report? And what happens to me afterwards? Hence a recommendation. I think one of the recommendations in here is around enhancing on the number of safe homes. Let's have safe homes that are specific to sexual violence cases, etc. And one of the issues we have had is you are separating some of these victims are children. You are separating them from the family structure. You need to start with the whole child-centered or child-focused counseling. You need to get into all those things, and some of them cry and say, I want to go back home. We are taking children back into the homes of abusers. There are districts that don't have safe homes. And we are grateful for the CDF vehicles, because in some of our implementation areas, those CDF vehicles are helping transport victims from court into a safe home, etc. Because we had instances where victim support unit officers were working with the victims to the court and back and traumatizing the victims because they were interacting with the alleged perpetrators. We've also had instances where we are being told you can't take the victim into this person's home because there are no safe homes. Our mobilizers or our matrons on the ground have to take these children into their homes, and we're being told it's against the law, which it is. So we have to retain those survivors into the homes in which they were molested. So these are the circumstances we are working with. When we say we are requesting that budgetary allocations be increased because we want, is it 10 safe homes in a district? We know what we're talking about, and we are not talking from without. Differentiation sentencing. I think this is something that I bring back to you, Honorable Munsanje. I think when it comes to the lawmaking process, as legislators, sometimes we need to ask you around what was the spirit in differentiating some of these things, because when you look at some of the effects or consequences of an incest and what you are calling a defilement, it's something that the proof is there. There's a child born out of it. There's transmission of serious infections. There's etc that you can speak to. So when you look at the gravity or the gravity of what has been done against the victim, and you look at the fact that sentencing is different because one has aspects of a relationship of a blood relationship or consanguinity, and the other one is just rendered as defilement, these are things that we need to look at. Are we going to have just one offense? Is it defilement? And we just, as we are expanding on it, say defilement by this one or defilement by which one? For me, I believe we need the same sentences. We need the mandatory minimum that applies if it's for defilement, applying to even incest in our opinion. And then you're speaking to if the perpetrator is a female or a perpetrator is a male. I think more often than not, when you look at I'm not a scientist, but when you look at scientific makeup, what presents the larger damage, quote unquote? Is it when the offense is committed by a male or by a female? But those are conversations that we can open up and have. But we also, for me, I believe we need to have aggravated sexual offenses. That way, you look at what has happened. The Kanyama case, for example, where the boy contracted an STI. The contraction of an STI is an aggravating circumstance. So if the law had to be changed, maybe that would be a minimum of 15 years, for example. Consider the aggravating circumstances. If there is an infection, etc. Because we've seen, I had a client who was 3 months old in my past life and molested by the father. And when you look at the damage that was done, it gives me sleepless nights up to now. And that is why I said, I'm leaving, I will not do sexual violence work anymore. So those are the things that we have to work with and that we have to see all the time. So when you're talking about differential sentencing, I'm thinking in terms of what are the aggravating circumstances, because sometimes when it's a female that is involved, you will not even know, you will not even see some of these things, for example. So these are conversations that, for me, I am not saying yes or no, but I believe these are conversations that need to be ongoing, and as our lawmakers, and as we will come next time to submit, are you going to support us when we say that we need aggravated sexual offenses, and this is what is aggravating? Because for now, I think the courts see that, which is why we have the kind of sentences that we see. What happened? Was there a child born out of that? Was there an infection? Is there fistula? Are there colostomy bags, for example? Those are some of the aggravated circumstances that we can look at. But Honorable Musanje, I think those are conversations that we need to have to see how do we amend and how do we incorporate into our laws, so that we're not seen to favor one gender over the other, and so that we understand that what we are looking at is the fact that there has been a violation that has been committed against the victim, regardless of their gender. But we should also be alive to the fact that the greater number of victims when it comes to sexual offenses are children, and these are female children, and you also have women. And when you look at the statistics that we have provided, defilement makes up for the larger number. And then you come to the rapes and everything else. Thank you very much, Honorable Chair.
Thank you for the submission. I think we have to end here. No, we have to end here because it has taken us 1 hour 5 minutes. So we still have other witnesses waiting. So I think we have interacted enough. At this juncture, let me thank the witness for ably submitting to this bill, to add value to the composition of the report, and we feel you have substantially attended to it, though it was much on this section of rape, defilement and incest, but however it is a major part of the bill. So let me at this moment remove the immunity that was granted to you, so that you continue serving our people well. Thank you very much and have a good day.
Thank you. Do that.
Registration continues. The Electoral Commission of Zambia has extended the voter registration exercise for 15 days from Wednesday the 12th of November 2025 to Wednesday the 26th of November 2025. This is to capture as many eligible voters as possible. If you're 18 years and above, or if you will be 18 years on or before the 30th of April 2026, a Zambian citizen and in possession of the Green National Registration Card NRC, you qualify to register. If you registered in 2020 or during continuous registration of voters and you still have your voter's card, you don't need to register again. The following services will be provided: new registrations, replacements of lost, destroyed or defaced voters' cards, transfers from one polling station to another, claims for omission on the register of voters, corrections of clerical errors and removal of deceased voters. Registration centers will be open daily from 8 hours to 17 hours including weekends. Note that the 15 days of voter registration exercise will have 3 phases. The first 2 phases will last 4 days each, while the final phase will last 5 days. To find open registration centers, check on the Commission's website. Follow the link ovr.org.